Okay, I was talking to a kid. He was, I don't know exactly, but he was at court and he was trying to figure out basically how to overturn a wrongful conviction. Now, he said that they got his confession or something or another, but he said it was under duress. He didn't say duress, he said, but, he couldn't afford bond. He was locked up, and they told him, sign this, and you can get out, fight it. We'll throw more charges at you, and this will take longer. And I said, well, yeah, how long? I forgot how long he said before they did that, and they said that violated a quick and speedy trial. You can ask for it, but they won't give it to you. But there's limitations on it, and if they exceed those limitations, you can have your case dismissed with prejudice. Okay, so I told him to file a motion to quash. Okay, so a motion to quash in Illinois is a legal quest to void a court order such as a subpoena or to invalidate an arrest, quash arrest, or suppress evidence. It is used to challenge improper service, lack of jurisdiction, or unlawful procedures is granted. It stops a subpoena or can lead to some dismissal. Motion to quash service, motion to quash arrest and suppress evidence used in criminal cases to challenge an arrest made without probable cause, or if evidence was illegally obtained, it often argues the officer's actions were unlawful. Motion to quash subpoenas, procedure, effect. Okay, you want to scroll down here. Okay, this is in Illinois. Motion and notice forms, Office of Illinois Courts. Okay, so it's basically the same in every state and even for the federal government. Okay, you just have to look. So, since I'm in Illinois, this is where we're going. Okay, kid, I hope you see this video. I showed him legal reform on Facebook, on his phone. He sent himself a couple videos or a couple of my posts. Said he was going to go over everything, so I'm going to leave this here. Okay, motions and notices. Form title. Okay, so let's see. Let's go. Let's, easy forms. Okay. Motion. Okay. You'll need your case information, what you want the court to do. Okay. The names and addresses of the other parties in your case. The names and addresses of the lawyers in any case, if any. What documents will you need? For how to file and send a motion and notice. Motion. Okay, so you just see what it says there, see? Okay, so that's where you're going to start your motion to quash. Okay, so he really doesn't have much. They didn't give him much, so basically, failure to disclose. Disclosure is mandatory. Everybody's supposed to see, it's called discovery or discovery of facts in court, but that's called disclosure. So disclosure was given to everybody except him. So he didn't have the ability to give informed consent. In order to give informed consent, he needed reasonable knowledge. He needed reasonable knowledge to make an informed decision to give informed consent. And he didn't have any knowledge, so I told him, okay, this is all you got to say. That's what I do. Okay, I was showing him, I gotta go. So I scrolled all the way down. And I told him, you don't have to say much. And once he read it, he had the biggest smile on his face. He said, God damn. He was a young guy. I don't know, mid-20s. He said it was a UUW, unlawful use of a weapon. So he's going to go over there, open up that motion to quash, and he's going to copy and paste. Okay. Because, in taking the oath, public servants, this is all the legal obligations behind that oath. And I've been trying to get them to do their job. See, that's the long version. Okay, but all he has to say is down up to here. Okay, let me read it to you. I told him this is all he has to say. Titles a conspiracy against rights under the color of law. The judge failed to report my counsel and the opposing party for multiple counts of misconduct and themselves for judicial misconduct. The opposing party failed to report the judge for judicial misconduct, my counsel for ineffective assistance of counsel, and themselves for misconduct. My counsel failed to report the judge for judicial misconduct, the opposing party for misconduct, and themselves for ineffective assistance of counsel. Reporting misconduct is mandatory in both the rules of professional conduct, the code of judicial and the code of judicial conduct. Failure to report is misconduct just as well as a failure to enforce one's constitutional duties as prescribed in the rules and the codes. The lack of requirements of the Sixth Amendment of the U.S. Constitution is beyond unethical. The lack of effective assistance of counsel doesn't allow for a fair trial, which shows due process didn't exist. A deprivation of rights in its entirety. It clearly shows the judge and attorneys in my case committed a conspiracy against rights under the color of law, which prohibits the willful retention of rights, privileges, or immunities under the color of law. Okay, there are no immunities for doing that. Okay, under USC 241 prohibits conspiracies to injure, oppress, threaten, or intimidate any person in free exercise, enjoyment of any right or privilege secured by the Constitution or the laws of the United States. I trust you will live up to the oath and show competence, diligence in expediting litigation, as I've had meritorious claims and contentions. So I strongly stress reporting professional misconduct and maintaining the integrity of the profession. I trust communications will be made for ethical violations, and every penalty will be imposed. In the public interest, as trustees, this is how to maintain the public trust. Failure to do so would add to this conspiracy against rights under the color of law. That's it. That's all you got to put there. And that opens and closes your case. Exoneration. If that's what you want, exoneration. That's all you need. I've used it. I got a guy out of prison, from Centralia Prison, in 1991 on a late notice of appeal. Just saying that. But they limit what you could put, on the motion to quash. So if you can put more, because I got an eviction, a wrongful eviction. So I'm going to take the rules in the codes to make sure everything goes by the book. And if this is the same judge I had last time, he thought he was king of the court. Didn't have to go by the rules. Didn't hold the lawyer to the rules of professional conduct. He's supposed to reporting misconduct is mandatory. And the lawyer filed a fraudulent, frivolous case. Yes, it was an eviction, but I was moving. And the landlord, in retaliation, because she wanted me to do some more stuff so she could sell the house at a higher price. But anyways, I said no, and I was moving. I had my stuff in storage, and so she got a lawyer and had me evicted. But there was no cause. I was moving. And when I went to court, I told the judge, hey, I was moving. And I can't move because he filed for an eviction. And the judge said, is that true? He said, yeah, well, she wanted him out. And yeah, that day, Your Honor, but it was ridiculous taking me to eviction court when I was trying to move. Here I am talking to somebody about getting an apartment. They ran a background check and they says, oh, you're being evicted? I said, I am. And I couldn't find an apartment, and I wound up paying a massive amount of money for a security deposit because of this wrongful eviction. But it was thrown out, and the judge gave me 90 days. But the lawyer never took the eviction out, and so I had to pay a substantial amount of money just to find another apartment, security deposit, 4-month security deposit. The other ones wanted 6 months, and 2 of them wanted a year. So, so I'm going to go ready. I'm going to make sure. I'm going to use, this is the Code of Judicial Conduct, Canon 2. A judge shall perform the duties of judicial office impartially, competently, and diligently, ensuring the right to be heard. So I'm going to tell the judge, okay, I want to just, Canon 2 Code of Judicial Conduct ensures me the right to be heard. And he'll shut the hell up. Because failing to abide by Rule 2.6, assuring the right to be heard, a judge shall accord to every person who has a legal interest in the proceeding of that person's lawyer the right to be heard according to law. So if the judge doesn't do that, guess what? Then they wind up violating codes after code. A judge shall perform her duties of judicial office impartially, competently, and diligently. Impartially, well, they're supposed to give you the right to be heard. Competently, they give you the right to be heard, and they don't keep you from speaking. Okay, so I'm going to tell the judge that responding to judicial and lawyer misconduct. So I'm going to tell the judge, it's your legal obligation to report this attorney basically a slap suit. Fraudulent and frivolous eviction. And then I said, Judge, knowing that another judge has committed a violation of this code that raises a substantial question, or a fitness of judge, in other respects, shall inform the Illinois Judicial Inquiry Board. Okay. But the one I want, right here, D, a judge knowing that a lawyer has committed a violation of the Illinois Rules of Professional Conduct that does not, says does not. It would be a judge knowing that a lawyer has committed a violation of the Illinois Rules of Professional Conduct that raises a substantial question regarding a lawyer's honesty, trustworthiness, or fitness as a lawyer, in other respects, shall inform the Illinois Attorney Registration and Disciplinary Commission. So that he's already violated that. A judge shall uphold and promote the independence, integrity, impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety in all of the judge's activities. And them not hearing you out, and if it's the same judge, he tried to humiliate me, degrade me, talk down to me, yelling at me, simply because I wasn't a lawyer, but he didn't know I knew the rules and the codes and laws. But he never gave me a chance to speak. He let the lawyer speak, and then when they found out I wanted a jury trial, everything changed. And the lawyer withdrew and gave me 90 days to move. And I says, as long as you move that wrongful eviction, I can move. Like I would have been out already. but he never did. But I wanted to move closer to where I needed to get my operations, and before the doctor would do either or knee operation, he said I had to be somewhere where it was one floor, that I didn't have to go up and down stairs, and so I needed to move. Promoting confidence in judiciary, that's shot down the hill. Avoiding misuse, the prestige of judicial office. So you can cite them for that because they didn't give you the right to be heard. Canon 2, a judge shall perform the duties of a judge of office of partiality competently and diligently. And you could cite them for that because he's showing favoritism, bias, because you're not a lawyer. And because he thinks you don't know the law, he's going to, make up stuff. So I mean, you see that No Kings protest? It's not just about politics, it's about the kings in the court, too. The judges, they think they're above the law. You got to take the rules and the codes with you if you want your case, no matter where it's at. This is just eviction court. But no matter where you go, if you don't take the rules and the codes with you, the legal obligations of all lawyers and judges, you're going to lose. Giving precedence to the duties of the judicial office, a judge of the judicial office prescribed by law shall take precedence over all the judges' personal and extrajudicial activities. Rule 2.2, partiality and fairness. Judge shall uphold and apply the law and shall perform all duties. So there's a lot of laws I mentioned that they aren't going to do. So they're on my page, legal reform. So ain't none of that going to happen if you don't know that. And take copies with you. Take a copy of the rules and the codes with you. That's what I'm doing. That's what I've done for a long time. That's how I got Social Security. A judge shall not, in the performance of judicial duty by words of conduct, manifest bias or prejudice or engage in harassment, including and not limited to bias, prejudice, harassment, based upon race, sex, gender identity, religion, national origin, ethnicity, pregnancy, disability, age, sexual orientation, marital status, socioeconomic status, or political affiliation, and should not permit court staff, court officials, or others subject to the judge's direction in court to do so. See, so this is all the stuff they're, once I told you, they're supposed to give you common courtesy, respect, but they won't. So you won't get it unless you go over it with the judge, and I'm going to go over it with the judge. Proceeding before the court shall be conducted without manifesting bias, prejudice, or engaging harassment based upon attributes. Okay, so it even says religion, national origin, ethnicity. Racial profiling is a thing again. And that's violating the rule of law, number one. You know what the penalties are for violating the rule of law and the judge allowing this? It says right here, it's the judge's duties not to let this happen. Anybody to violate the rule of law. But you got people, all public servants violate the rule of law if they're not living up to the oath. Violating the oath, fines, removal from public service, and incarceration. I always tell people to start with the oath. Why? Because they're not going to, if you don't mention the oath, the obligations of, and the penalties for violating that oath, they're not going to live up to it. They're not. If they're not living up to the oath, they're not fit for office. They're not fit for public service. Taking the oath requires putting the oath before anybody, anything, yourself, your boss. It's illegal to give unlawful orders. So it's unlawful to give unlawful orders as well as taking unlawful orders. If you know somebody's giving you unlawful orders, basically telling you to violate the Constitution, to make due process null and void, etc., that's an unlawful order. So anybody taking that unlawful order will still be charged accordingly as a connection with the person that gave those unlawful orders. And the penalty can be just as harsh. Ask anybody from the Judge Advocate General's office. Ask any lawyer. It's illegal to give unlawful orders as well as taking them or fulfilling those unlawful orders. And by doing so, that's a conspiracy against rights under the color of law, which is violation of federal law. Okay, what competence, diligence, and cooperation. See, there's a lot of stuff. Once you can't violate just one code. It's impossible. You're going to want to use all this. This is what I'm going to go over with the judge. And they're not going to want to talk to me. They'll probably throw the case out, call for a sidebar. I want as many people to go with me as possible because judges, they will call those sheriffs on me and take me in the back for contempt of court, and I'll never get out of there again. I've been through that already. The wrath of a judge. A judge shall disqualify himself or herself in any proceeding which the judge's partiality might reasonably be questioned, including but not limited to the following circumstances. Okay. Being a dick on the benches, you can just read this and tell you they can't. Okay, a non-representative role helping parties to resolve dispute over this matter. Some of these roles apply directly to lawyers who have served third-party neutrals. In addition, the rules that apply to lawyers are not active in practice of law or participating lawyers, even when they are acting in non-professional capacity. For example, a lawyer who commits fraud in the conduct of a business is subject to discipline for engaging in conduct involving dishonesty, fraud, deceit, misrepresentation. Rule 8.4. Rule 8.4. In all professional functions, a lawyer should be competent, prompt, and diligent. A lawyer should maintain communication with a client concerning representation. A lawyer should keep in confidence information relating to representation. I delved into the rules of professional conduct. That's what I'm going to talk about, everything that lawyer's not doing to bring this fraudulent and frivolous case up against me. And they'll all do it. See, so I got a lot to say. See, this is right here, the rules that lawyer is violating. Competence, scope of representation, diligence. We'll get into that later, but that's what I want to bring up. The communication. I tried to communicate with that lawyer, and he decided he was just going to take me to court. Now you need to get a lawyer. I think he's going to need to get a lawyer after that because the judge is going to have to cite him for all these violations. Confidential of information. He's supplying some fictitious evidence, saying I violated a lease from 2023. I haven't signed a lease in... I definitely didn't sign one in 2023 with the last people that owned the building. I even have emails and texts her demanding I sign the lease. Meritorious claims and contentions, they don't have that. Candor towards the tribunal, they aren't doing that, so I will. Fairness to the opposing party, what's fair about that? This is just legal harassment, and I already talked to the attorney maybe a week or two ago, and I tried to explain to him that this is legal harassment, and this is what's going on, and you can't do this. Truthful statements to others, Rule 4.1, dealing with unrepresented persons, so he's definitely in violation of that. Responsibilities of partners, managers, and supervisor lawyers. So we're going to find out exactly. He works for a firm. Responsibilities of subordinate lawyer. Reporting professional misconduct. and misconduct. Okay. So the lawyer, I told him, you know, so he's going to have to report himself. The judge is going to have to report him. If the judge doesn't report him, the judge will be in contempt of the very court they're presiding over, and I will bring light to that. I'm asking for a jury trial. I already filed for a waiver of fees. Judges don't like jury trials. But I'd rather be judged by 12 than buried by 1. Okay, so like I said, you could throw that on a writ of habeas corpus too. You could throw that on a motion to quash, writ of habeas corpus, that writ of certiorari with the U.S. Supreme Court. So you can just put that little bit I said in the beginning, okay, right up to here. Failure to do so would add to this conspiracy against rights under the color of law. Okay, so just that little bit right there says a whole lot. There's all this down here. And that's nothing compared to what I could add on to that. You know. Okay, people, this is Popset Legal Reform. Unaccompanied adult to some. All right, you have a good night. Okay, may your Creator always be with you and rain many blessings. I wish you nothing but a long life and good health, peace and love.